Hello, I'm Barbara Levin, the Executive Director of Neurofibromatosis Mid-Atlantic. Welcome to the Top 10 Tips for Success in the Special Education Process, presented today by attorney James Silver, who is substituting for the ailing Ellen Caligari. I want to thank you so much for joining us for this exciting and informative program. We are joined today by people from throughout the world. We're very happy to be sponsoring this educational event. Because we have some folks who are joining us today who are hearing impaired, I've written down my opening remarks. We will provide a closed caption version as soon as is possible. NF Mid-Atlantic is a nonprofit organization based in Baltimore. We've been around for 34 years and remain committed to our founding principles of supporting people with NF, their families, their caregivers, and anyone who has an interest in NF by providing awareness, support, and education. For a few housekeeping items. There is a question pane on the right side of your screen. If you have questions during the presentation, simply type in your question and click Send. At the end of the presentation, we will do a Q&A session to take as many questions as time permits. I will be muting everyone while Mr. Silver speaks, but feel free to write your questions. This broadcast is being recorded and will be available on the NF Mid-Atlantic website at www.nfmidatlantic.org by April 26, 2013. It will also be available on our YouTube channel, NF Mid-Atlantic. You can view all our archived webinars at our website and YouTube channel. To be informed of release, please subscribe to our channel, follow us on Facebook, or at our Twitter stream at NF Mid-Atlantic. We're so honored to welcome James Silver. He's a senior associate attorney at the law firm of Caligari and Steedman. This event will help you become more aware of your child's legal rights and where to find assistance. Topics will include the Individuals with Disability Education Act, IDEA, and the Americans with Disability Act, ADA. This talk is one of our most requested webinars, so we're particularly grateful for this opportunity. Before we start, I'd like to remind everyone that NF Mid-Atlantic survives solely on your donations. If you would, please consider a donation in any amount. You may do so at www.nfmidatlantic.org. We are a tax-exempt 501c3 nonprofit organization, and we've made donating very easy. There are two events I'd like to announce before we begin. May 19, 2013, we're holding our first bowl-a-thon for NF. Details are on our website, or email us at events@nfmidatlantic.org. And for those of you who are golfers or want to be, we are auctioning off a foursome for June 14, 2013 to be part of the Greater Potomac Golf Classic to raise awareness of NF and to benefit NF charities. Details are on eBay and on our website. Email us if you're interested or know someone. Thank you again. We have some fabulous plans for our future events, and we'll keep you informed. Now, if you'll indulge us for a second, I'm going to turn this over to James Silver.
Hi, this is Jim Silver. I am, as Barbara said, the Senior Associate Attorney here at Caligari and Steedman. Ellen was going to be presenting this morning but fell ill, so I will be stepping in for her today. Certainly, this is a presentation that she and I have worked on before. So it is, as it says, Top 10 Tips for Success in the Special Education Process. And I'm going to move on to the tips here in a second. Just want to let you know what we'll be looking at for each tip is a little example of how things can be frustrating, particularly during the IDEA, IEP, special education process, and some tips about how to maybe hopefully improve the experience for you a little bit, and hopefully improve the results as well. So these are our tips, and we'll explain each one as we go along. Number one, don't lose your temper. This is number one because it really is one of the most important things to remember when dealing with IEPs. It can be extremely frustrating, and we have some ideas about how to try to keep your calm as you're in the middle of going through these emotionally fraught, occasionally, meetings. Agree only if you really agree seems obvious, but we'll talk about why that's something that has to be considered. Request related services that meet your child's unique needs. Ask for help when you need it. Address behavior problems early. Set the table, not necessarily for dinner, but for the meeting appropriately. Clear expectations. Document everything. Trust but verify. And don't move too quickly to a hearing. That's a due process hearing under the IDEA. We will get to that obviously last, but it's something that goes last again because we want to make sure that everybody goes through all the steps before they get there. Number one, don't lose your temper. It can be a very frustrating process, I know. We certainly have clients who get frustrated and upset during the IEP process, and occasionally we as attorneys can get frustrated and upset. But when that happens, the IEP meeting stops being a discussion about what does this child need and starts becoming sort of an entrenched warfare between the school says this because they're feeling defensive and the parent says this because they're feeling upset. And everyone stops listening. It's easy to say keep calm, but when you're in the middle of the meeting, it's hard to actually remember to do that. So here are some ways to remember to actually keep calm and hopefully keep your temper about you. Don't go alone. We obviously, when we attend a meeting with parents, they aren't alone. They have an attorney with them. But even if you're not taking an attorney, it's important to have someone on your side of the table. If it's your husband or wife, if it's a friend, if it's your sister or brother, a grandparent. We'll talk a little bit later about other people who you could take with you, people who you are paying to take with you, but who can provide advice and counsel. But whoever you go with someone. And it also helps to be able to recollect what happened during the meeting and reconstruct, well, how did we get into the middle of that discussion? How did this happen? If somebody else is there, they can provide some input and let you know. Remember to take a break when you need one. It's, again, these can be lengthy meetings, particularly if it's something where you're trying to ask for something and the school system says no. It's important to remember, I can stop this for a minute, collect my wits, think about why I think this is important, and maybe come back and appeal rationally rather than being emotional and upsetting people. Number two, agree only if you really agree. As we say here, you get into the meeting and there's a discussion, and the discussion goes on, and somebody makes a recommendation. You're hearing IEP speak maybe, or you think that they're saying one thing and you want to go along with what they're saying because it sounds reasonable. Make sure that you're agreeing when you really need to agree. You don't want to upset them. That makes sense. These are people who are working with your child day in, day out. Or it can be very unpleasant to be in the middle of a conflict. Whatever the reason, people will end up agreeing to IEP provisions, a goal, or an aid or service that they didn't really mean to, or that they look at later and say, I don't like that at all. One of the ways to make sure you are agreeing to what you mean to agree to is to review the meeting notice. By law, you're supposed to get notice of the meeting well in advance, far enough in advance to prepare. And if you look at that meeting notice, you want to make sure that the purpose of the meeting is what you think it is. If it's to review an evaluation, if the school has recently conducted an evaluation, that should be listed on there. You don't want to get in and find out that, in fact, this is only a meeting to, for instance, to decide whether summer services are warranted. If you don't see what you think should be on there, if you think that this is a meeting to review an evaluation, ask in writing, whether that's email or a letter, that they add that. I don't have very many citations in here. This is one of them. This is a citation to the federal regulation dealing with meeting notice. And if you take a look at it when you have a chance, you'll see that it does describe what should be listed in the meeting notice. Also listed in that notice are the meeting participants. By law, there are certain people who are supposed to be involved. The child's teacher, the parents, if there's specialists like a speech-language pathologist or an occupational therapist, they should be invited. They should be invited and listed on the notice. There should also be somebody who is able to make decisions about placement, who can make decisions about services and providing those services, and you should see that person as well. Again, if you don't see those people listed, you should go ahead and write to them, to the school by email or by letter and say, hey, I think so-and-so needs to be invited to the meeting. You should also request copies of all documents that will be reviewed at least 1 week in advance of the meeting. In Maryland, there is a law that requires that documents to be reviewed at an IEP team meeting must be provided 5 business days rather in advance. That's not the law everywhere. That's only in Maryland. But it's always a good idea to be able to ask for it. It gives you time to prepare. It gives you time to read what you're seeing, read what you're going to see at the meeting. And if something's confusing, you have time to look at it and prepare for it and figure out what you want to ask questions about. And this all, as we say at the top, agree only if you really agree, this all helps you make sure you understand what's really being said and that you know for sure what you're agreeing to. We would also recommend, in addition to getting copies of the school, from the school of what they want to present, that you give copies to the school as far in advance as possible that you would like to present at the IEP team. This gives them a chance, again, to prepare if they see something in there that they aren't sure what it means, or in many cases, it gives the school a chance to prepare for what's going to be requested. In some cases, people at the last minute hear a request and they say no because they don't think it's possible. If you give them notice in advance and give them a chance to prepare for it, it gives them a way to work their heads around what's being requested. This would particularly include if you have a consultant conduct a psychological evaluation, or a private speech-language pathologist, or a private occupational therapist, or a tutor. Any teacher that works with your child outside of school, if they write something up, we would recommend giving it to them far in advance. I should add, by the way, this applies to IEP team meetings, certainly, but also applies to 504 meetings, if you're having a meeting to prepare a 504 plan, and would also apply even if you're just going to meet with the child's teacher. If you have something you really want to discuss with that teacher, it helps to provide it to them by email even, a few days in advance, a week in advance, just so that they have a chance to read it over, and you can then also streamline your meeting and say, this is what we really want to talk about. At the end of the meeting, when you have the IEP and there have been lots of revisions made, it's easy to get to the point where you feel like you need to sign it and be done with it. Take your time to decide what you really are agreeing to. You can walk away with a draft and say, I need to read this and think about it because of all the changes we've been making. I will get back to you as soon as I can. And that way you know if you're agreeing to an IEP you really want, or if you are agreeing to an IEP that doesn't seem to reflect what you thought your child needed. You can ask, as we say here, that the IEP remain as a draft until you respond and either consent or don't consent. In addition, I would say this, again, we say IEP here, but this would also apply for a Section 504. If you're looking at it and you think there's something you really wanted, at the end of the meeting you don't think it's been on there, ask to take some time to look at it and get back to them about it. Again, this is a citation that talks about your chance to consent as a parent to the provision of services. And when you walk away from the IEP with that draft, from the meeting rather, with that draft IEP, you can give it to someone else and have them read it and talk to you about it, whether that's your spouse, whether that's, again, a tutor working with your child. And there may be, you may find language in there that doesn't actually make sense to you when you walk away from it. If you are reading the IEP and it says, the child will demonstrate the following skills, and you look at the skills and you say, I don't know what those skills are, that probably means you're going to be agreeing to something you may not actually understand. And it could be an unpleasant surprise later in the process if you discover that. So go back and ask the team, hey, can you revise this for me? If you get to something that seems really thorny, we would recommend talking to either an attorney working in special education law or an educational consultant to review that with you and explain what it means and whether or not it's something you really want for your child. You can also ask the meeting to reconvene to review what you've asked, what you're concerned about, and at that time you can bring the educational consultant or an attorney with you to advocate, to present the reasons why they're concerned, or to possibly translate from IEP speak that the team is using into plain English that you can understand. You should also, when you get to the meeting, if you're disagreeing, we recommend often putting something in writing so that you can go through and say, I disagree with this proposal for this reason. It helps to let the team know that this is specifically what you're concerned about. They may be able to make revisions to address that. In other cases, they may say, no, this is what we're going to do. It certainly helps, to go back to tip 1, to keep your calm when you have it in writing. You're reading it, you're not trying to argue with them, and you're not trying to present a case that may be emotional enough that your words get away from you. Once you disagree, if the school continues to disagree with you, if they aren't able to compromise with you or make revisions that satisfy you, the school is required to provide you prior written notice. Again, we have a citation here to CFR, the Code of Federal Regulations, that specifies exactly what has to be in the prior written notice. I would say, in short, the biggest issue is that there needs to be something in the prior written notice that says, this is the specific point of disagreement, and this is the basis that the school used to make their decision. In many cases, we see prior written notice, and it doesn't say really why anybody made that decision. It just says, we looked at some reports and we decided. They have to be very specific, and again, I would recommend, if you have questions about it, certainly contact an attorney or look at CFR to see what's supposed to be in there. Number 3, related services for your child. The IDEA requires, and I believe 504 as well, requires school systems to provide not just special education, but related services as well. That can be speech-language services, that can be occupational therapy services. If the school says no, they often will use the basis of, well, we just don't have somebody here to provide those services at that time. Sometimes they say it's not a related service. That's well, as we'll see in a moment, really not the case. Related services can include any service that helps benefit from special education. That's music therapy. We've had students who receive that. Aquatic therapy. We've had some students who receive horse riding therapy. The legal definition is inclusive. This is in the definition in CFR. There are examples of what is a related service, but it doesn't say anything is not a related service, with one exception. The only thing that's specifically excluded are maintenance of surgically implanted devices. The school system's not required to be responsible for those. Almost anything else can be a related service, however. That also includes, I should add, transportation. In many cases, transportation is required to be provided if it's not the local school, or if a child needs a particular type of service on the bus, if they need. Some children need specific restraints, but many children also just need an aid to make sure that they're safe on the bus. Another specifically named related service is parent counseling and training. You can ask for training if something's working at school, and especially if the school says that they're seeing behaviors or results that you're not able to see at home. You can always ask for training in what methods they're using that are successful. It should be used at school and at home if it's a success, because that way you can see exactly what's working. The site here is the definition of parent counseling and training, I believe. ask for help when you need it. This is something that specifically applies to attorneys, certainly, but it can apply to really anybody that you may need to ask for help from. Some people come to us, some parents come in, and they've been working for a year or more, and they really didn't agree when they started off, and now they really disagree. They want to come in and ask for a due process hearing right away. That's usually not successful in terms of filing for a due process hearing that way. It's often not the way we recommend resolving the issue. And it can be a very complicated process if parents have been disagreeing with the services that are provided for a very long time. So when you realize you need help, you should ask for help. Don't be afraid to talk to an educational consultant. That means somebody who has training and expertise in how special education is provided, a psychologist or psychiatrist, or an attorney, or a private speech-language pathologist, or an occupational therapist. If you have a question about how the service is being provided, call them. You don't have to hire them. You don't have to retain an attorney to work with you forever and ever, but you can certainly call the professionals and just say, this is what I'm dealing with. Can you answer my questions and just let me know what this means? You will certainly have to pay them for it, or in most cases you will have to pay them for it, but it may just help to be able to get a half-hour or an hour-long consultation with someone to be able to discuss what your questions are. It also means that if you have that relationship built up, when things start getting intense, you can call that attorney, that educational consultant, that psychologist to attend a meeting with you. It will mean that you have that support, that firepower, so to speak, to be able to discuss why a particular intervention is being requested. It will also mean that if you get to the point of needing to go to a due process hearing, that expert's already there. They know your child. They know what's going to happen, and they can say to the hearing officer. I apologize, to the hearing officer for the due process hearing. This is what my observations were. This is what the IEP team said, and this, in my opinion, is why, my professional opinion, this is why their answer was not a valid way to deal with this. So again, this goes back again to keeping your calm, having somebody on your side of the table, and also being able to cut through the IEP speak and make sure that you are hearing what the school is really saying when this expert can sit in the meeting with you. Address behavior problems early. We have parents come to us and their child has been suspended or expelled, or is in the middle of a serious disciplinary process, or in some cases is in the juvenile judicial system, arising out of behavior problems at school. If you think that your child is having behavior problems, ask the IEP team to perform a functional behavioral assessment. And when they finish that functional behavioral assessment, you can ask them to consider a behavior intervention plan. This means that if you start seeing teacher notes or reports in IEP progress reports or report card comments that talk about behaviors, and that's maybe just, not paying attention, or that a particular other student is not getting along with your child, you want to ask for that behavior to be assessed right away, rather than waiting until this becomes a full-on conflict between two students, or until your child can't concentrate and really isn't able to remain in the classroom and receive instruction. Don't wait until trouble starts. It's better to be proactive, and the school may resist doing a functional behavioral assessment, but it also puts it on the record at some point in the future, if there's a behavior problem, that you've asked and you've tried to deal with this, and if the school is not willing to do it, you can then come back to them and say, look, I asked you guys to deal with this a while ago. I think this is what we really need to include in the IEP or in the 504 plan. Set the table. As as I said, this is not involving setting the table for dinner, but setting the table for the IEP team meeting. It's important to have the right utensils and the right people at the table no matter what you're doing. You don't want to let the meeting start without the people you need. There's also occasionally a request that from the school that a particular personnel or staff member be excused from the meeting, either very early or before the meeting starts. We would say don't excuse them. Make sure you have everybody at the table when the meeting starts, especially if you think you need to present any information and the teacher or the staff member may be able to contribute. And it may surprise you who knows and who can talk about your child's needs. An IEP team has to include parents, the general education teacher, at least one special educator working with your child, if there is a special educator working with your child, and, as I mentioned before, a school system representative who has authority to make special education decisions. That means that someone can make a decision about placement, someone can make a decision about services that should be provided, especially, for instance, I think one common example, if a child needs speech-language services, the answer shouldn't be, well, our speech-language pathologist is only in the school 3 days a week, 2 days a week, 1 day a week. If that's a service the child needs, there should be a school system representative there who can say, you know what, we'll make more man-hours for this speech-language pathologist to be at the school. And also a member of the team should be anyone who has evaluated the student. That means the psychologist who did the evaluation, the occupational therapist who did the evaluation. In many cases, we see a team where the team convenes and there was a recent psychological evaluation. The school psychologist who did that evaluation, he can't make it that day. Instead, this person is going to review the evaluation. Or this speech-language pathologist is going to review the evaluation, but the one who works with the child isn't able to attend today. We would generally recommend rescheduling that meeting to make sure that the person who really has the most pertinent information can attend. If that means that, in fact, there are 2 school psychologists, somebody who works with the child regularly and somebody who did an evaluation, there are 2 of them at the meeting, so be it. They're both going to have really important, crucial information for the team, and it's important to make sure they're actually able to be there at the table on the day of the meeting. If you do not need someone, like a general education teacher, in many cases we see that as the gym teacher or the librarian. You can agree to excuse them after the meeting starts, but you want to make sure they're present at the beginning of the meeting. I was just reviewing whether we have a second here. I'm going to keep going. I have some examples that I can provide if anybody's interested later. As I said, it's important to have a representative from the central system at every team meeting who could make these decisions, for instance, about placement or about services. And this is required by law. The CFR site here describes who should be a member of the team meeting, and it does specifically state there should be someone who has the power to really make decisions, not just the local school staff who say, we can't do that. Move on to clear expectations here. It's important to make sure that the IEP is specific as possible and clear as possible. We often see IEP goals or present levels of performance or progress reports that just say, teacher report. The progress on this will be tracked by teacher report or informal reports. If you see that on an IEP, in my experience, it often means that that's going to be reported as making progress because that's the way the IEP progress reports are formulated. It's easy for a teacher to see a child, and particularly if it's a child they like, to report that that child's making progress. And if the only way of tracking that is teacher reports, then there's really a difficult time in contradicting that. What you want to say is a clear expectation of how is progress defined. Is it 4 out of 5 times that the child has a chance to do something, they do it? Is it 80% of the time? What does 80% of the time mean in this case? You want to be sure that that's clear and specific. Who tracks the progress? Is it an aide? Is it the classroom teacher? Is it the speech-language pathologist? Who is going to be tracking that? How are they going to be tracking it? And rather than just having teacher reports, you want to ask for data that backs this up, whether that means that somebody has been sitting in the back of the room with a little sheet ticking off each time they see a behavior. You want to get that data collection sheet. If it means that it's the school psychologist's report on how many times they've met with a particular student, you want to see that report. If it's just a one-paragraph or two-sentence or three-sentence report that says, met with Jimmy and we discussed frustrations. You want to see that. You want to know what that means. Again, this is important to be able to talk to the team and say, here's why I don't think progress is really being made. And it also helps you keep your calm because you have data to back you up. It gives you something to give to the attorney or the psychologist or the speech-language pathologist to be able to say, here's what they're saying to me, but I'm not seeing it. So again, you want to very clearly and specifically define your progress, what progress means rather. And once the IEP is complete, once you have a clear definition of how you're tracking progress, you want to meet with the teacher privately, one-to-one or two-to-one, to meet with to review how the data is collected. And that means, again, being specific about who's doing it, how are they doing it, are they sitting in the back of the room ticking off behaviors? Who's that going to be? Is that going to be the aide? Is that going to be the paraeducator? Is that the classroom teacher? Because they're standing up front. They're going to have a hard time doing that. Ask for copies of any data collection sheet they're going to use so that you can see here's how it's formatted, here's what we're going to be collecting, here's the specific behaviors we're going to be collecting data on, here's how we're going to format it. In many cases, in some cases, we've certainly seen that once parents see that, they look at it and they say, oh, you know what, this behavior, we don't see that behavior anymore. And the teacher says, come to think of it, neither do we. Well, that doesn't mean that's a success. That means that for this IEP, that means that's already been addressed. That can come off the data collection sheet. You can provide some feedback on that. And you also want to ask for going back to asking for documents ahead of time, ask for the progress data before the meeting. You can review it. You can say, this day doesn't look right. This was the day he was out of school. This day doesn't look right. He was having a terrible time that morning. Why is it that you say he was calm all day? Well, it turns out the child was in the resource room all day, maybe. If they don't have that, ask them to bring it to the meeting. If they can't give it to you ahead of time, ask to bring it to the meeting and review it at the meeting because, again, it's important to check and make sure, is progress really happening? How is it happening? How are we defining it? And if we disagree, we are sure what the terms of the disagreement are. This relates to, obviously, documenting everything. Every conversation you have with the teacher, it doesn't mean, not every conversation. If you say you're going to volunteer for the ice cream formal, I'm agnostic about whether or not you provide an email about that after the fact. But certainly every conversation you have concerning your child's progress, concerning the IEP, concerning services that are being provided, or any concerns you have, or any concerns the teacher have, all those conversations should be carefully documented in writing and politely documented in writing. Going back to keeping your calm, I would recommend if you're writing an email to the teacher, and you're concerned whether or not you have used impolitic words, you may want to stop, walk away from the email, do something else for a little while, come back and reread it, and make sure that it's a polite and generally friendly email to the teacher, and it's not going to be something that somebody later looks at and says, this is really hostile. And the reason you're documenting it is not because they're liars or they're untrustworthy. It's because caring and diligent teachers can completely forget a discussion, even after they've intended to do something, even after they've been implementing things. Teachers can forget what they said. My wife is a teacher, so I'm not revealing secrets out of school, I don't think. It doesn't have to be a formal. It doesn't have to say, we met on such and such a date, and we discussed the following things, bullet-pointed list. You can just say, thanks for meeting with me. I really appreciate you taking the time because I know you have a busy schedule. We talked about the data collection sheets, and we decided that we will revise the sheets the following way. Let me know when the revised sheets are available. I'd like to take a look at them. It can be, as I said, friendly, chatty, polite. Polite and informal aren't necessarily mutually exclusive. You can also make an audio recording of IEP team meetings. There is, at least in Maryland, certainly a law that you are allowed to document the IEP team meeting. I believe that's generally the case. I will not swear to it, however. We would advise that you let the school system know ahead of time to avoid disputes about taping. There are certainly rights that the teachers have the right not to be recorded if they wish. Because parents generally have the right to make an audio recording, the teacher is allowed to have the meeting stopped, have the recording rather stopped, to present a report, and then to have the recording restart and to have a summary of their report provided. As I say, we would advise letting people know ahead of time so that there's not any unpleasant surprises, and also so that nobody feels like they're being ambushed by a recording. Trust but verify. I think this really does go back to the data reports and the clear expectations. After the IEP team meeting ends, after the IEP's been revised or the 504 plan's been revised, and you think you know what the school is doing, even if they said very clearly what they were going to do, you still need to closely monitor the progress and the implementation of that plan, because the best intentioned teacher can still forget to start implementing a plan if they need to. Confirm by email that this is what was said and this is what they're actually going to be doing. If the teacher isn't responding, or if the teacher if you're not successful in communicating with the teacher, confirm it in an email to the principal. If you don't see it in the meeting summary, but you're sure that you discussed it, send an email and say, I believe we discussed talking about doing the following 4 things. If it's not in the IEP, send an email and say, I thought we'd agreed that we were going to do X, Y, and Z. Maybe somebody revising it ended up accidentally deleting it. It's better to document it in an email and verify that you actually had that discussion. If you believe that the team has made a revision after the fact, certainly you should go back and verify this is what we discussed. Again, an audio recording of the meeting will be helpful here. Any notes you take for yourself will be helpful here to be able to discuss this is what we had discussed and this is what I'm verifying we were going to do. You can also schedule an observation of the classroom. There may be school system regulations regarding observations, but write in and see if you can observe it and take a look at how that's being implemented. One thing that we've noticed is obviously your child recognizes you when you come in the classroom and they see you there. We often recommend an educational consultant for that purpose to be able to do the observation, sit in the back of the classroom. It's a new face. It's not somebody that the child necessarily knows. And they can then come in and get an accurate view of what's going on. And finally, all of this supports the idea of not moving ahead too quickly to a hearing. When IEPs aren't working out, IEP meeting gets fraught, gets emotionally heated, or there's a long-standing disagreement with school staff, it's easy for parents to be seduced that they're going to have a hearing and it's going to be a resolution that they want. We would say, let's tamp down that dream a little bit. Due process hearings are often long. There are multiple days, usually, and those days are usually, or in many cases, not consecutive. It doesn't mean you have a 5-day hearing in 1 week. It means often that you have a 5-day hearing spread over the course of a month or more. In addition, if you are going to a hearing and you're going to be presenting evidence, those expert fees and your attorney's fees can add up quickly. And it can be a pretty major expense for you to deal with. And at present, the law will allow you at some point to recover attorney's fees. It will not allow you to recover experts' fees unless there is a specific state law to that effect. there has certainly been a move afoot to allow parents to recoup experts' fees after a due process hearing if they win, but that is not the state of the law at the moment. And even if you have the best evidence, the best experts, the best attorney, there's no guarantee you'll win. Anytime you go to a hearing, you are putting the future of your child in the hands of an administrative law judge or an independent hearing officer. You don't know who that person is, you don't know what their background is usually, and you don't know where they are, what incentives they have in their background that may motivate them to make a decision. Not to say that somebody is necessarily corrupt, but somebody may have had an experience with school, may have had an experience with their own child or with their grandchildren that lead them to believe a certain way, or they may think that, parents are greedy. It's not all independent hearing officers are entirely objective. It's always a crapshoot to be able to have that person making the decisions. So we always caution about moving ahead to a due process hearing because, as I say, it can be a lot of power in the hands of one person. We would also add that you should never go to a due process hearing unless you have an expert, a speech-language pathologist, an educational consultant, or a psychologist, because when you go to that hearing, the school system's going to have an expert. They're going to have teachers, school psychologists that are going to be taking the stand. They're going to be talking about why the school system is right. If you go to a hearing without an expert, you're going to have a very, very difficult time. And you should always be ready to compromise. If the school system makes an offer and it's part of what you'd like but not everything, think very seriously about it because it may be better to rely on a cliche, a half a loaf is better than none. If you get to that hearing and the hearing officer goes against you, it can be a bitter loss when you realize that you could have had half of what you wanted. We have a little bit of information here with some links online for the CFR regulations. We also have a handbook on our website written by Ellen Caligari and Wayne Steedman detailing the special education process that's specific to Maryland, or particularly for Maryland, but a lot of that applies generally. And that concludes our portion of the presentation.
Well, that was wonderful. Thank you so much, Mr. Silver. That was an incredible amount of information, and we're so appreciative. And we do have a number of questions, and we'll try to go through as many as we can. We have about 4 questions that I would like to go ahead and ask you on behalf of the people in the audience. We got a number of questions about finances. You did mention that there is an ability to recover attorney fees but not expert fees, if we understood that correctly.
That's correct. I want to be clear that if you are, it's for parents who are, the law says, the prevailing party. It means if you win at the hearing, you can recover fees. I should clarify that also means that if the school system appeals it to court, if you went at the hearing, the school system appeals it to court, you need to win at court too.
Oh, interesting. Well, some of the questions had to do with whether one does not, I'm assuming that this means that you upfront the money to an attorney. And if someone does not have the financial means to upfront money to an attorney, risk not recovering attorney fees or hiring an expert, can you give us an idea of what some of the options might be for them?
There are a couple of options. First of all, I believe in every state there is a parent advocacy organization that will, in many cases, can refer you to an attorney to talk to you. As I said at one point, you can ask for a consultation, which is not necessarily the same thing as retaining an attorney. You don't have to pay you're going to have to pay for a certain amount of time to talk to them. You can just consult with an attorney that way, or you can go through the parent advocacy organization. I believe they usually have, I don't want to say weekly, but I believe there's usually a scheduled time when the advocacy organization will make some attorney hours available to chat with parents. I know, for instance, in Maryland, there is the Maryland Disability Law Center can provide some advice. The Howard County Autism Society recently set up a program to allow some hours with attorneys to answer parent questions. So if it's just a matter of asking questions, there should be a resource available to get some of those questions answered. Wayne Steedman, one of the other partner here, in addition to Ellen Caligari, is a regular speaker at the COPA, C-O-P-A-A conference, the Conference of Parent Advocates and Attorneys. And COPA usually will be able to provide you a resource to let you know somebody in the area who could provide some answers for you.
Thank you. On a similar vein, there were some questions because so many of our parents have to take off work. They wanted to know if the IEP team meeting officials were flexible as far as time. Are there times, for instance, ever in the evening?
In my experience, no.
Mm-hmm.
I mean, you can always ask, and the worst answer you can get is no, which leaves you right back where you started. But I would generally say no. I would say that we've said to parents, certainly it can be tough to take off work for multiple meetings. I think a lot of these tips will help clarify what you're doing at any individual, any given meeting, so that you really, we aim to have more productive meetings than not. So you don't want to go to 2 meetings if you can get it done in 1. And I'd say that if you can particularly make sure that everybody is there when you need them to be there, that will help avoid taking off time from work as much as possible.
Thank you. Our friend Diana Baldwin left us a note saying, who is on this, I have referred to Diana often, so that's why I don't mind saying her name. She left us a note that the state of Maryland, for instance, provides a booklet entitled Parental Rights, which has a wealth of information about the IEP process as it relates in the state of Maryland, which I suspect that our listeners should check. Tell me if you agree, Ms. Silver, that they should check their individual states for.
They should check what they receive. There is a requirement that parents receive notice of their rights. There's a requirement in federal law that they receive some notice of their rights. Generally, that document, whatever it is, whether it's called Notice of Parental Rights or Parent Rights and Procedures, will also have some information on resources to go back on attorneys that are available in the area. Again, there should be something in there that is low cost or free, but most of them are not going to be low cost or free.
Thank you. One of our listeners says that she has a son who has a no gym order from his surgeon. During this period, I'm going to read this, and I suspect you will understand it better than I possibly. No gym order from his surgeon. During this period, they have him to sit and watch. I understand this somewhat, but he had surgery and is in a wheelchair, but he wears a leg brace now. He's 10 years old, and she feels he can do something besides just sit and watch. I did bring this up at his IEP, and he was told that he would be given something, but that has not happened as yet. She continues with another question. What can she get anywhere with this?
Let me address 2 parts of that, I guess. I think, first of all, you're correct that they should be providing something to do other than just sitting and watching. That's really not addressing the child's individualized needs. And it's something that often we see adaptive PE or adaptive physical education listed when there's a situation like that. Adaptive physical education can certainly be a lot of different things. There can be, we've seen some school systems that will use a Wii, but that's the Nintendo Wii, that is, to let kids do, some upper body stuff. Maybe they're playing tennis or doing something like that. Or, they can, at the very least, offer some written work on health and how to have a healthy lifestyle. There are lots of possibilities. I would say if you had this meeting if you had this IEP team meeting and the team said, yeah, we can do something about that, I would go back to the trust but verify that we talked about. Send them an email and say, this is what I thought this is what we discussed. I'm not really seeing anything, or my son says that he's not having any of this happen. What can we do? What are the specific proposals that you were going to put in place? Did I misunderstand, or is this something that's going to be? What's the start date if we think this is actually happening?
Thank you. We have another question that if the state does not meet a child's needs and you put them in a different school in that state, can you get the state to pay for this change in schools?
That is, I'm going to have to give, I think, a short answer to that because it can be a complicated answer. Yes, you can get the state to pay, or it would generally be the local school system and not the state itself. I could be wrong. I mean, if it's other than Maryland, I will be a little bit out of my depth on it. But in terms of what the law says, yes, you can ask the federal law says that you can ask the school system, I have had to place my child in this private school because you have failed to provide a free, appropriate public education. As a result, I'm placing my child in this specific non-public school. I'm paying for him to be placed there, but I am going to request that the school system reimburse me for that placement. The law says that that's called a unilateral placement notice or a unilateral placement letter. You can do that by letter, which is by law required to be provided 10 business days in advance of the change of placement. Or you can give that notice at the last IEP team meeting before the change takes place. So if you attend an IEP team meeting, you ask them to make the following 5 changes to the IEP. They say no, and the next day that your son's going to be starting at the local non-public special education facility. You can say, well, as of tomorrow, he's going there for this reason. As I said, that's supposed to be provided 10 business days in advance by the federal law. Giving that notice doesn't automatically do anything. It's not a magic bullet. Usually, in my experience, if you give notice to the school and say, I expect reimbursement, the school's response will be, no, I'm not going to reimburse you. You may have to go through the IEP process. You may have to go through a due process hearing or mediation. Something is probably going to have to be required after that change in placement. But if you wish to be reimbursed by the school system, you should provide them that notice, because otherwise, by law, you could be completely right. You can go through the due process hearing and be vindicated that they hadn't offered a free, appropriate public education. But if you have not given them notice, you can be denied all reimbursement altogether. And I would recommend anybody who is considering that kind of change of placement contact an attorney at least just to ask a question about it, because it can vary state to state. The timeline, as I said, is federally mandated, but you want to get some answers about that so you preserve your rights.
Thank you. We're getting wonderful questions, and we're getting a wide array of them, but I think we only have time for one more, possibly two. And we have a question, interesting question about timing. My son is currently in middle school, and we just had an IEP meeting, and it went very well. However, I am concerned about the time when there's a transition time. How do we ensure that the IEP reflect when he enters high school?
Okay. I will answer this as best I can. I may not be quite clear on a couple of the aspects of it. First of all, transition can mean 2 or 3 different things. There can be a transition between classes. It doesn't sound like that's what we're talking about here. There's also a transition. There's also the transition from outside of school, the transition from not being in school to not being in school. And also, it doesn't sound like that's what we're talking about here. It sounds like we're talking about the transition just between middle school and high school. I would say if you're going through the IEP team meeting and it's getting close to high school time, it's late in 8th grade, or you think this is going to be the last meeting in 8th grade, ask that somebody from the high school be there. They should have someone there, because when high school begins, that's a change in the placement, and that placement change should take place before the actual high school day begins. Otherwise, they are arguably predetermining a placement or illegally implementing the IEP in a placement other than what was specified on the IEP. So you should have a meeting that allows for that transition, and you should have somebody there who can talk about, well, here's how we can implement it or not. You should also have a chance to visit and walk around and take a look at the placement, at the transition placement, the high school that is, before that day happens.
Thank you. That's very sage advice. We do have a lot of questions, but I'm afraid that we are out of time. If I may, Mr. Silver, I'm going to request that if people have prevailing questions, perhaps they can get them to me. And you all have been given our email, and we will try to post whatever we can. We will be posting some information from the law firm of Calgary and Steedman. And also, if we may, we're going to check in with Mr. Silver or Ellen Calgary throughout the year, and just if there are changes in the law, presentations that they will be providing, we'll be able to check in. I believe we agreed to that. Is that correct?
We have to see if we can figure out the mechanics of it, but I think we'd probably be happy to do something like that.
Thank you so much. I'm sure
I would, if I could just add one thing. Anybody who absolutely has a question, if you have a burning question, especially, I mean, obviously we're happy to talk to anybody in Maryland. But if you are elsewhere, please do take a look either at COPA and your local Parents and Procedures Manual and see if you can find an attorney, because I can give you some general answers, but it's an individualized education plan, and generally you want to have an attorney or somebody answering your question who can really take a look at the individual needs of your child.
Well, thank you so much. This was so jam-packed with information and very thought-provoking for all our attendees today and later. As I've written here, I'm sure you agree that we want to thank James Silver for sharing this information, and what a great last-minute substitute. We also want to thank you all for joining us. By tomorrow, April 26, 2013, this session will be available for viewing in its entirety. So if you missed something, you can go back and watch it again with the slides. If you have a spouse or a friend who wants to see it as well, they can do it. You can view the slides and audio two ways: on our website at www.nfmidatlantic.org or on our YouTube channel, NF Mid-Atlantic. Before we close, it's incumbent on me to remind you once again that NF Mid-Atlantic survives solely on your donations. If you appreciated this webinar, please consider a donation. You may do so at www.nfmidatlantic.org. Our next series of webinars will be announced very, very shortly. In the meantime, if you're in the Maryland area, join us for the Bowl-a-thon, or at the golf tournament on June 14th, 2013. Remember that May is NF Awareness Month, and we will soon announce some special events. Thank you all very, very much. I will be closing this out for everyone, and I thank you again for joining us today. Goodbye.